1 million euro per year. Also
Yes,
at the... Okay. The second decision of the Federal Supreme Court, in its decision dated 2012, the Federal Supreme Court first reaffirmed that the free development of an individual must not only be respected by the state, but also by the monopolistic private individuals, such as sport federations. The Federal Supreme Court held that any decision of such a sport federation must be consistent with the fundamental values of in Switzerland. These fundamental values of public policy are not exhaustively defined in Swiss jurisprudence. One of these fundamental values is the provision in Article 27 of Swiss Civil Code, which is considered by the Federal Supreme Court as a substantial part of any moral and legal system. Taking into consideration Article 27 Swiss Civil Code, the Federal Supreme Court found that the worldwide ban of a professional football player for an unlimited time because of his incapacity to pay a certain amount of money to his former club is a breach of substantive public policy. Instead of promoting compliance with the decision, the punishment renders the payment completely impossible because the player would never be able to earn enough to pay his obligations. Okay, thank you.
Thank you very much for your presentation, dear Rochelle. This case, we mentioned first time the cash award has been overruled based on substantive law and not procedure law. Now, I would like to give the floor to the next speaker, Mr. Lawyer Martin Polijn. Martin Polijn is a consultant to the London Centre of International Law Practice and the director of Amicus Legal Consultants.
Good afternoon, ladies and gentlemen, and it's a privilege to be here with you today, and I'm grateful to the organizers for extending the invitation to me. We've heard something already in this session about the work of CAS, and I'd like to perhaps dwell on some of the outstanding issues and challenges that CAS faces, and perhaps some of the trends that we can look forward to as the years move forward. And I'd like to start, I suppose, by using a sporting comparison and saying that, of course, arbitration and sport make a good doubles partnership. It's clear from what you've already heard that there's a need to have a tribunal who can bring speedy resolution, can bring finality, and also transnational expertise. And clearly it's in the interests both of international federations and of athletes themselves that there's such an arbitral body. But there are challenges that need to be faced. And of course, the first of these, as you've already heard, is the importance of independence and impartiality. And one of the other speakers highlighted the issue of consent. We know, don't we, in arbitration, that the process relies on the consent of the parties. So what about the situation where there's an intrinsic imbalance between one party and another? On any reading, an individual athlete is not in an equal relationship with his or her governing body, with indeed the international federation governing his or her sport. And if I'd been standing here a year ago, I suspect we might have all been speculating on the future of CAS, certainly in respect of being seen as a fair and impartial tribunal. Why do I say that? Well, the case of Claudia Pechstein, and again, that case has already been mentioned in passing. I think it's worth spending a few minutes on the Pechstein case because it did have and continues to have tremendous ramifications. Claudia Pechstein, as many of you I'm sure will know, was a German speed skater. Indeed, I think had won something like 60 medals at international championships and at Olympics dating back to 1992. And she found herself engaged in a 7-year judicial fight against a 2-year suspension, a suspension for a violation of anti-doping procedures. Now, her case is interesting in the sense that she didn't give a positive sample. Instead, we were looking here at irregular blood parameters. So an unusual case in that sense. She was subject to a 2-year suspension from the ISU, the International Skating Union, based, as I've said, on, in effect, irregular blood measures. Now, she challenged it, and CAS nonetheless confirmed the suspension. She then launched proceedings, as she was entitled to do, before the Swiss Federal Tribunal, and as you've heard, the grounds for review of a CAS decision before the Swiss courts are very limited, and she failed in those proceedings. So instead, she launched proceedings before the German courts, proceedings for damages both against the ISU and, for various procedural reasons that I won't go into now, against the German Federation as well. Her action was for loss of earnings in respect of the suspension. Now, why is it interesting? Well, in a first instance, before the regional court in Munich, in fact, the court said she had not previously challenged the jurisdiction of CAS, therefore the matter was raised judicata. But they went on to say that, in fact, the arbitration agreement, to which, of course, she'd had to agree as an athlete if she was to compete internationally, was void because the ISU, as an international federation, had a monopolistic stance in relation to international competition. Now, that, the court said, would have been contrary to German antitrust laws and would have amounted to a restraint of trade. So, an interesting finding, quite a striking finding, the idea that the agreement would in itself be void. The matter went to a second instance court where, in fact, there was a different finding. The finding there was that the relationship between athlete and federation was not such that the arbitration agreement was void per se, but instead the court said you had to look at the particular circumstances of the agreement and the way in which it manifested itself. And they said, on the facts of the Pechstein case, you had a situation where, in fact, most of the body of arbitrators, the 270-odd arbitrators listed for CAS, because the majority of those at that stage had actually been nominated by sports governing bodies, there was, in fact, an unequal relationship. Now, at that stage, many people questioned what the future would be for the adjudication of these sorts of disputes before CAS, whether one would have a situation where one could say the tribunal was a fair and impartial one. The matter was then taken up to Germany's highest civil court, and the German Federal Tribunal, the BGH, then I think to the relief certainly of CAS, dismissed Pechstein's case, but in fact came to entirely different conclusions to either of the two subordinate courts. They said you've got to look at the structural balance or imbalance between athlete and federation, that there are beneficial interests for both athlete and federation in having an arbitral process. If that's the case, look, they said, at what's available to the athlete, the list of potential arbitrators, the fact that an athlete can veto the choice of an arbitrator, and the fact that on any reading, in their conclusion, CAS is truly an arbitral tribunal and is genuinely independent. So they, in effect, restored the credibility, one might say, certainly before the German courts, of the caste system. So what's the effect of that now? Well, looking forward, one has to say that the effect's likely to be much greater scrutiny of fairness of proceedings themselves. Clearly, athletes are not going to be in a terribly strong position to challenge the nature and structure of caste proceedings. But it's clear from the concerns the German courts had that individual fairness in a particular case is going to be a key issue. And I think also one of the emerging themes is the importance of international norms and, in fact, national laws as well. Now, this has been the subject of a lot of controversy before CAS and, in fact, before other arbitral tribunals. To what extent can an arbitral tribunal, in fact, disregard national laws? To what extent must it heed international norms? And we've had, again, very recent guidance on that, once again from the German courts in a judgment delivered just a few months ago in September of this year, in quite an interesting case concerning a small semi-professional German football club, SV Wilhelmshaven. Now, that particular club, back over 10 years ago now, had signed a young Argentinian player and had been ordered on the basis of signing that player to pay training compensation fees to the two Argentinian clubs to which he'd previously been contracted. Those training payments were ordered under FIFA's own rules, and the small German club, Wilhelmshaven, who are not necessarily the richest club in the world, disputed those payments and in fact refused to pay. The upshot after that was ordered back in 2008 was that FIFA ordered relegation of Wilhelmshaven. And of course, having ordered relegation, it was then down to the local football association, in this case the North German Football Federation, to put into effect that relegation. And again, there was a challenge by the club before CAS. The challenge was unsuccessful, so again there was recourse to the German courts, and once again the case found itself before the highest civil court in Germany. And there was a finding in favor of the club for a number of reasons. First of all, the statutes of the North German Football Federation at the time were in fact less than clear, but more importantly, there was a finding that sports authorities are in fact subject to both national and of course international, and in this case EU law. Now, the argument that the football club had put forward was that the Argentinian player actually also held Italian citizenship, and therefore, of course, under the EU treaty, Article 45 as it now is, they were entitled to rely upon his rights of freedom of movement, freedom to choose an employer, freedom of discrimination on the grounds of nationality. And the upshot was that the relegation was set aside and couldn't be put into effect. So I think the importance here is that a sports governing body at the national level can find itself in some difficulties. On the one hand, it might be under instructions from an international federation to put into effect a ruling. On the other hand, it can't escape the fact that it's subject to its own national laws and, of course, international laws, in this case, a regional instrument, the EU treaty. Now, the other finding was that the federation itself, of course, as the North German Football Federation, was an affiliate of FIFA, was bound by its rules, but individual clubs, who of course are affiliated to their federation, not to FIFA, were not bound by FIFA's statute, by FIFA's rules.
Please.
some important issues there. So where does that leave us? It leaves us, I think, with this dilemma. Sometimes people speak about a growing body of international sports law. Some people have spoken about a lex sportiva. In other words, a freestanding body of global law that reflects the globalization of sport. And I think in the light of these sorts of judgments, one has to doubt whether we've yet arrived at that lex sportiva. There's a reminder, I think, there that whatever the restrictions through an arbitral agreement in taking your case to a national court, the reality is that if the arbitral tribunal itself hasn't had regard to international legal norms, whether they're rule of law norms, international human rights law, particularly in respect of anti-discrimination, for instance, then there are likely to be ways to challenge the tribunal, because the reality is, we all know that it's very difficult for an arbitral tribunal to oust the jurisdiction of courts entirely.
Conclusion, please.
Yes, there might be an issue about the validity of an arbitration clause, and on the doctrine of competence, we know that the arbitral tribunal should be the first resort to adjudicate that. But in reality, if you fail there, there are often ways to rehearse that again before national courts. And the German examples are useful examples of those. That's not to say that internationally there's a uniform approach. I think we need to note that, for instance, US courts have adopted what one might call a differential approach to CAS adjudications, and have not been willing to intervene even when it's transgressed US national law. And the obvious example, the well-known example, will be the case of the US sprinter, Justin Gatlin, and the refusal of the courts to intervene with his, what was originally an 8-year suspension, then reduced to 4 years. But I think that differential approach has not, on the whole, found favor with European courts and with some courts in other regions. So I think the way forward is going to be that eventually we might arrive at that lex sportiva, but we're certainly not there yet. I know the time's pressing, so on that note, I'll finish. Thank you.
Thank you for your presentation, dear Poleni, and for your reference to lex sportiva system and procedure to the CAS. I would like now to give to the floor to the next speaker, who is Alfonso Leon.